Good morning, everyone. I'm Judge Corey Amanda Cawthon, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. Remember that today is not your trial date, so I encourage you to speak to your attorney before speaking on the record this morning, because everything that we say today is being recorded and can be used against you at a later date. If you're represented by the Public Defender's Office, attorneys for the Public Defender's Office are present both here with me in the courtroom and at the main jail. For those of you that are at other facilities, know that these attorneys are available to you by phone. For those of you who are represented by private counsel, know that your attorneys come here to the courtroom to address your case from here. If your attorney is not present in the courtroom when I call your case, please let me know and we will try to facilitate you through that process. However, I ask you not to tell me that you have private counsel unless you or your family have retained counsel for this specific arrest. You also need to know that in the courtroom with me, I have attorneys from the State Attorney's Office, as well as representatives from confinement status, pretrial supervision, and the Clerk of Courts. All of these persons are here to facilitate this morning's session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here at First Appearances if you are here for misdemeanors and municipal ordinance matters, but understand that that is dependent on what is going on with you personally and your case. For felony matters and violation of probation matters where the judge has already placed a no bond hold, know that those cannot be changed or resolved here at First Appearance this morning. After today, your case will be assigned to a specific division judge, and going forward, all pretrial motions and any subsequent trial will be heard before the divisional judge. All right, before we get started, Mr. Miller, you said that there were some cases that the jail requested to be called out of turn?
Yes, Your Honor. We provided a list to the court.
Okay. We'll go through those first, and then I'll go with whoever signed them. So the first one that I have in my hands is Antoine Dupree.
Judge, if we could put him on recall, he's using the restroom.
Okay. When I get the list. When I get the list, I will call out the case number, the page numbers. I'm just waiting for them to get pulled out of the stack right now.
I'm looking for Wade on 10 right now.
I'm sorry? All right, Mr. Dupree was on page 20.
And Wade is 10.
Okay,
Page 10.
Jeffrey Wade, who's on page 10.
He's approaching, Judge.
Thank you.
Come on up, Mr. Wade. Judge, we're going to be waiving formal reading of the charges.
All right, very well. I've reviewed the charges and the probable cause affidavit. I do find probable cause for these charges. I will hear from the parties as to bond.
Your Honor, I see no history. That being said, based on the serious nature of these charges and the strength of the evidence against Mr. Wade, I'm requesting a bond in the amount of $10,000 per count. Should he post bond, pretrial release with a GPS monitor, no contact with minors, and no possession of any devices with internet access until further order of the court. Nothing further.
Mr. Romero?
Judge, Mr. Wade's not going to be able to go forward what the state is requesting. I understand the nature of the allegations. However, I'm gonna be requesting $5,000 per count. With the number of counts, if my math is correct, I believe it's gonna be somewhere around $55,000, and that's gonna be tough house stance for his family to come up with. But in speaking with Mr. Wade, as you heard from the state, he has a clean record. He's 52 years old. He's self-employed. He's a hairstylist. He's been living in our community for the past 15 years. Specifically, he resides in West Park. He resides with his wife. My understanding, Judge, they rent. They do not own. Their monthly rent is approximately $1,900 per month. My understanding, Judge, his wife is employed. She works at a local retail clothing store. My understanding, Judge, he's been a hairstylist doing that for the past, basically 33 years. He goes back and forth and actually works in Louisville, Kentucky. That's where he has clients. Judge, what we were going to be asking for the court to consider is a $5,000 bond on each count. We don't have a problem as far as no contact, what the state requested, no sort of possession of any internet-controlled devices. We don't even have an issue with him being supervised on pretrial. What we would be asking for is standard pretrial based on the fact that he has no prior offenses. But we're going to be asking for a $5,000 bond on each count on Mr. Wade's behalf, Judge.
Well, let me ask this before I decide as to the actual monetary bond amount. Aside from what my ruling is going to be on that, I'm inclined to put him on, if he does post the bond, have him on pretrial on a level 1 GPS. My concern right now is that if I impose the order that he has no contact with minors, which I will be doing today. The issue is that I did see from the probable cause affidavit, I believe there is a minor child that resides with he and his wife.
And Your Honor, typically, in this type of situation, I wouldn't necessarily have an objection for no contact with minors, not to include any immediate family or biological children. I don't have any evidence to indicate there's any issues with his child.
All right, the allegation, Mr. Romero, did you
Judge,
have something you want to say?
yes, I have one other thing. I heard the court contemplating as far as what kind of conditions, and specifically, I know, I believe the court mentioned level 1. Judge, as you heard, Mr. Wade is working. He's the main financial provider of his household. As I advised, level 1 would basically have him being under house arrest and not being able to go out basically for any sort of reason besides, I believe, medical emergencies, to visit his attorney, things of that nature. Considering, Judge, he has no prior offenses, I'm going to be asking the court not to impose a level 1. As I did state earlier, he works. He goes to and from Louisville, or he has clients there, and that's the majority of his income comes from that. So, Judge, I'm requesting not to impose a level 1 pretrial.
Is he, Mr. Romero, does he work locally, or is all of his work to Kentucky? Because I can tell you right now, he's not going to be traveling back and forth to Kentucky based on these allegations at this time.
It's basically all of his clients are in Louisville, Judge.
Well, that's not going to happen. State, do you have anything further you want to add?
Well, the only thing I would note is if his clients are out of state and he would have to go to see them anyways, then frankly, it doesn't matter if it's a level 1 or a level 2. He can't travel
That's
outside.
why I was asking. So once again, I'm going to ask one more time, is any of the work done here locally? Because I'm not going to approve him traveling out of state.
No. None of them locally.
All right, I'm going to impose a $7,500 bond per count. Additionally, if Mr. Wade does post his bond, he will be placed on pretrial with a level 1 GPS. Additionally, there will be a court order in effect that he will have no contact with minors, excluding his biological child and immediate family, until further order of the court. Additionally, he will not possess any devices with access to the internet until further order of the court. Great, thank you. Okay, what cases are going to need a Spanish interpreter?
Judge, there's 3 individuals here on Maine that require the service of Spanish interpreter. First individual is on page 10, Mr. Vladimir Gasper. Second individual is on page 12, Mr. Tony Valdez. And third individual is on page 21. His name is Mr. Pedro Hernandez.
Thank you. All right. And for my interpreter, will you raise your right hand, please? Do you swear or affirm to interpret from English to Spanish and Spanish to English to the best of your ability?
I do, Esteban Rojas.
Thank you, Mr. Rojas. Okay, first up will be Vladimir Gasper.
He's approaching Judge Maine.
Okay, once again, he's on page 10. Good morning, Mr. Gasper.
Buenos días, señor Gaspar.
Buenos días.
Good morning.
You're before the court on count 1, resisting an officer or obstructing without violence.
Usted está ante este tribunal por un cargo de resistirse a un oficial de policía o obstruirlo sin violencia.
Count 2 is a municipal ordinance violation for
El segundo-
trespassing.
El segundo cargo es por violar una ordenanza municipal, entrar ilegalmente en una propiedad.
I find probable cause.
Considero que existen indicios probables
And I'll hear from the parties.
y ahora escucho a las partes.
Judge, in speaking to Mr. Gasper, he's looking forward to contesting these allegations.
Señora juez, luego de hablar con el señor Gaspar, me informa que él desea apelar en contra de estas acusaciones.
My understanding, speaking to Mr. Gaspar, from what he advised me, he was basically sleeping.
Tengo entendido que el señor Gaspar, según me informa, básicamente ha estado durmiendo.
And then law enforcement made contact with him.
Y luego los oficiales de policía entraron en contacto con él.
Now, I haven't had an opportunity to review the PC affidavit, but that's what I was advised.
No he tenido la oportunidad de revisar el affidavit sobre indicios probables, pero eso es lo que se me informa.
Now, Mr. Gasper is 46 years old, been living in our community in South Florida for the past 15 years, Judge.
El señor Gaspar tiene 46 años, ha estado viviendo en nuestra comunidad del sur de Florida durante 15 años, señor juez. Señora juez.
He is indigent, he is homeless, Judge.
Es indigente, no tiene casa,
He works when he can by help people with construction projects, but that's not something stable.
trabaja cuando puede ayudando con proyectos de construcción, pero eso no es un trabajo estable.
Now, my understanding, he has prior contact with the criminal justice system, but it's been a couple years.
Tengo entendido que ha tenido contacto con el sistema judicial penal anteriormente, pero ya han pasado un par de años.
Judge, considering these are misdemeanor, non-violent offenses, I'm going to be asking the court to consider releasing Mr. Gasper ROR or in the alternative on pretrial release.
Señora juez, dado el hecho de que estas son contravenciones no violentas, voy a solicitar que su señoría contemple la posibilidad de liberarlo bajo palabra o, en su defecto, bajo medidas cautelares.
State.
Fiscalía.
I don't have And I don't have any issue with an ROR considering the allegations.
No tengo ningún problema con que se le libere bajo palabra tomando en cuenta las acusaciones.
But Mr. Gasper has to understand he's not going to be getting any court notice in the mail.
Pero el señor Gaspar tiene que entender que no le va a llegar ninguna notificación por correo.
So it's good. I'll wait till Mr. Romero's done. All right.
Esperaré a la contraparte.
So it's gonna be his responsibility to get his court notices.
Así que será responsabilidad de él percatarse de cuándo tiene que presentarse ante el tribunal.
Mr. Plant, do you have anything you want to add?
To resolve his case to adjudicate time served.
Él podría resolver su caso
If not, he's gonna get a warrant when he doesn't, if he misses his court.
con una
Homeless, so I don't know if he's gonna be able to find his court.
una condena de culpable y se le descontaría el tiempo ya, acreditaría el tiempo ya descontado. Él es indigente, así que no sé si él va a poder darse cuenta cuándo tiene que presentarse.
So that's for the municipal ordinance violation.
Eso sería para
Yes, Your Honor.
el caso de la ordenanza municipal. Sí.
Is there any offer for the resisting?
¿Hay alguna oferta para el tema de resistirse al arresto?
If Mr. Gasper was inclined to resolve the matter, the offer would be a withhold.
Si el señor Gaspar desea resolver el tema, la oferta sería un fallo sin condena. Señor Plant, para el otro cargo sería una condena y tiempo ya descontado, sí.
So, Mr. Romero, if he wants to resolve the case today, then count one would be a withhold in court costs.
Bien, señor Romero, si él desea resolver el caso hoy, el primer cargo sería un fallo sin condena y costas judiciales.
Count two would be an adjudication time served.
El segundo sería una condena y se le acreditaría el tiempo ya descontado.
Otherwise,
Let me ask you.
okay, otherwise I will, I'll ROR him to standard pretrial.
Si no, lo liberaría bajo las medidas cautelares de rigor.
Judge, he wishes to accept the state's offer.
Señora juez, él desea aceptar la oferta de la fiscalía.
All right, Mr. Gasper, will you raise your right hand?
Bien, señor Gaspar, levante la mano derecha.
Do you swear or affirm to tell the truth?
¿Jura o afirma solemnemente decir la verdad? Yes.
Do you understand everything that we've discussed here today?
¿Entiende todo lo que hemos discutido aquí hoy? Yes.
Is anyone forcing you to resolve your case?
¿Alguna persona le está obligando a resolver su caso?
No.
No.
Are you under the influence of drugs or alcohol?
¿Se encuentra bajo la influencia de drogas o alcohol?
No.
No.
Do you need any more time to speak with your attorney?
¿Necesita más tiempo para hablar con su abogado?
No.
No.
Do you understand that you have the right to a trial, but you are waiving that right by taking a plea today?
Entiende que usted tiene derecho a juicio, pero usted está renunciando a ese derecho al aceptar esta oferta hoy.
Sí.
Yes.
Have you ever been treated for mental or emotional illness?
¿Alguna vez ha sido tratado por una enfermedad mental o mental or
Or emotional illness?
mental o emocional?
No.
No.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Entiende que si usted no fuera ciudadano de los Estados Unidos, el aceptar una oferta de este tipo podría exponerlo a ser deportado. Yes.
Yes.
What plea do you wish to enter, guilty or no contest?
¿Cómo se declara? ¿Culpable o no me opongo?
Culpable.
Guilty.
All right, Mr. Gasper, I accept your plea
Bien,
and
señor
find
Gaspar.
that it is freely and voluntarily given.
Acepto su declaratoria, considero que se ha presentado de manera libre y voluntaria.
And once again, your sentence as to count one
Y una vez más, su sentencia para el primer cargo
will be a withhold of adjudication
será un
plus
fallo
court
sin condena
costs.
y costas judiciales.
Count two will be an adjudication time served.
Para el segundo, condena y tiempo ya descontado.
No. Next is going to be Tony Valdez.
Judge, I've been advised he bonded.
Okay. cause. And next will be Pedro Hernandez.
He's here, Maine.
Thank you. Okay,
Señora juez, el señor Hernández ya pagó la fianza para el primer y segundo cargo.
Mr. Hernandez, for the record,
Señor Hernández, para que conste en acta,
you're before the court on count 1, grand theft.
usted está ante este tribunal por un primer cargo de hurto mayor,
Count 2, possession of a vehicle with altered
el
numbers.
segundo cargo, poseer un vehículo con la placa alterada,
Count 3 is a felony probation violation from Miami-Dade.
el tercer cargo es una violación de la probatoria por una felonía del condado de Miami-Dade.
The probation violation has a no bond hold.
Y la violación de probatoria no tiene posibilidad de fianza.
I have been advised that your bond was posted on counts 1 and 2.
Se me informa que usted ya pagó su fianza para el primer y segundo cargo,
So I find probable cause for these charges.
de manera que considero que existen indicios probables para estos cargos.
And you'll be going to Miami-Dade shortly
usted
to address that matter.
Se presentará en breve ante Miami-Dade para abordar ese tema.
Thank you.
Gracias.
Is there anyone else who needs the assistance of a Spanish interpreter?
Nobody else here at Maine, Judge.
Is there anyone at any of the other facilities who needs a Spanish interpreter? Okay, thank you, Mr. Ramos. All right, so I'm going back to the stack for the individuals who are requested to be called out of turn by the jail. Amani Prince on page 4.
I'm sorry,
Did he
Judge, what
bond
did you
it,
call?
Judge?
It's Amani Prince on page 4.
Bonded?
Bonded? All right, thank you. I find probable cause. Juan Barrios on page
He's approaching,
10.
Judge. Mr. Barrios, come on up, please. He's approaching, Judge.
Thank you. Good morning, Mr. Barrios. You are before the court on 1 count of assault. Count 2 is for touch or strike battery. I find probable cause, and I will hear from the parties.
Judge, in speaking to Mr. Barrios, he's not going to be able to afford a monetary bond. Now, he's 47 years old. He's been here his whole life. From what he advised me, he has a clean record. My understanding, Judge, where this incident, I believe, allegedly took place, was where he resides. It's a mobile home where he's been staying at for the past 10 years. He's employed. He basically works for a company that repairs seawalls, but he's not in a financial position to post his monetary bond. So, Judge, at this time, we're asking on these misdemeanor offenses for the court to consider releasing Mr. Barrios under pretrial release.
Your Honor, despite what Mr. Barrios might be advising Mr. Romero of, he does not have a clean record. Under the name John Uribare, failure to leave property upon order from owner, 2012. Possession of cocaine, resisting without violence, 07. Possession of cocaine theft, 04. Additionally, Your Honor, considering that he threatened the victim and her family to kill them, to strangle them, I am requesting that the $1,000 bond be kept in place with an order of no victim contact.
Based on the probable cause affidavit, it looks like the alleged victim resides in the same residence as Mr. Barrios. Is that correct?
Correct.
And Mr. Romero, does he understand that if a no victim contact order is put in place, he's going to have to find someplace else to stay for the time being?
I did speak to him about that issue. Correct.
All right. Okay, based on the allegations in the probable cause affidavit and the history that's been discussed, I'm going to leave the standard bond in place at this time. I'm also going to impose a no victim contact order. So, Mr. Barrios, so that you understand, no victim contact, in addition to not being in the same place at the same time, means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes.
Okay, thank you. Jesse Pierre is on page 18.
Mr. Pierre, come on up. Yeah. And Judge, whenever the court's ready, Mr. Dupree is ready after Mr. Pierre.
Okay. Okay, let me just take a look at Mr. Pierre's, the probable cause affidavit, because I just got it right before we came in this morning, so just give me one moment. All right, good morning, Mr. Pierre. You're before the court on one count of burglary of an unoccupied dwelling unarmed. I find probable cause, and I'll hear from the parties.
Your Honor, I'm going to be asking for a $10,000 bond, pretrial release of the GPS monitor, no victim contact, no return. Frankly, I would normally be asking for a higher bond, but I'm taking into consideration Mr. Pierre's age. Frankly, I know he wrote a letter of apology saying it was a mistake, but what concerns me is he has a history of these type of allegations as a juvenile. Well, and first, so the court's aware, he scored high enough as a juvenile that he was ordered to secure detention pending the filing decision in this matter. His history: 2017, burglary of an occupied dwelling, burglary of a conveyance, burglary with assault or battery, a second case of burglary with assault or battery, attempted murder, 2016, burglary of a dwelling. I am concerned. I'm obviously concerned for the safety of property, people's homes in the community while Mr. Pierre is out of custody.
Judge, I understand Mr. Pierre has quite a bit of contact with the criminal justice system, but he is 16 years old. He's been here his whole life. He isn't working. He goes to school. He goes to Boyd Anderson High School. He's a junior. Right now, he does have a passing GPA. It's a 2.6. He lives in Oakland Park with his parents. His father's not working right now. He's looking for work. And my understanding is the mother's basically supporting the household. She works at the convention center, basically making minimum wage. Judge, there's no way he's going to be able to afford $10,000, him nor his family. Now, we don't have an objection as far as the level of supervision, considering priors Mr. Lunder referred to. We're just asking for a reasonable bond. We're asking for a $2,500 bond on top of the level 2 supervision. That's our request, Judge.
I just want the court to be advised when considering the risk and really what kind of deterrence what he's gone through has been or really has not been. In January 2018, he was ordered into a maximum risk residential facility. He was just released August 1st of last year, and this occurred about 4 months later.
Mr. Pierre's case, I'm going to impose a $5,000 bond. If he posts his bond, then he'll be placed on pretrial supervision with a level 2 GPS. Additionally, there will be an order of no victim contact and no return. Mr. Pierre, I'm not sure whether you know the alleged victim in this case or not, but either way, no victim contact means no phone calls, no text messages, no third-party contact, no social media, and no return means that you are not to return to this location. Do you understand that?
Yes, ma'am, I understand.
Thank you. Antoine Dupree.
He's here, present, Judge May.
Thank you. Good morning, Mr. Dupree. Mr. Dupree, you are before the court on count 1, burglary of an occupied dwelling unarmed. Counts 2 and 3 are each for burglary of an unoccupied conveyance unarmed. Count 4 is resisting an officer obstructing without violence. I find probable cause, and I'll hear from the parties.
Requesting a $7,500 bond on count 1, noting Mr. Dupree was fleeing from law enforcement, brought law enforcement to this individual's home. It was an occupied residence, putting the potential homeowners in harm's way. $1,500 on each of the 2 burglary conveyances. $1,500 each on those. No victim contact, no return. Mr. Dupree's history: 2013, possession of cocaine, possession of BZP, 2 separate charges of possession of controlled substance, 32 months state prison. 09, possession of cocaine, VOP, 32 months state prison. Unlawful use of false name ID, 07. Felony battery, great bodily harm with a violation of probation, 04. Possession of codeine, 01. Multiple other drug priors before that, Your Honor.
Judge, and speaking of Mr. Dupree, he's, one moment.
I'm gonna say something, because.
Judge, Mr. Dupree, and speaking to him, this is coming as a surprise to him, these allegations. My understanding is he doesn't know anything about these facts or incidents, and he doesn't know why he should be here, Judge. We're just asking for release conditions, and I believe Mr. Dupree wants to address the court, but I just want to find out what he wants to say, Judge.
Take a moment.
Judge, at this time, nothing to add from the defense, Judge.
All right. In light of the allegations and the history that have been presented, I'm going to impose a $7,500 bond on count 1. Counts 2 and 3 will each be $1,500. There will also be a no victim contact order and a no return order. Mr. Dupree, I don't know if you know the alleged victim in this case or not, but no victim contact means no phone calls, no text messages, no third-party contact, no social media. No return means that you are not to return to this location. Do you understand that? Mr. Romero, I trust that you will advise him as his attorney.
Yes.
Thank you. I'm not sure if there's any other issues there that need to be addressed with the division judge. Vickery Walters on page 18.
Judge, I've been advised he bonded.
All right, thank you. I find probable cause. Michael Garnett on page 24.
Judge, I've been advised Mr. Garnett is in regular court, room number 7870.
Your Honor, I
Yeah.
just have one moment before we move on.
Go ahead.
Mr. Garnett is actually being arraigned on this case this morning in front of Judge Siegel.
Right.
He's got so I would just ask if the court be inclined to find probable cause.
All right. Then I find probable cause as to the ad charge for trespassing. Thank you. All right, so I'm going to take some individuals that have parties signed in if they are present in the facilities. On page 19, Daniel McKenna, his private attorney is present.
Good morning, John David on behalf of the defendant.
Good morning, Mr. David. How are you today?
Good, Your Honor.
Please approach the judge.
Thank
Come on up,
you.
sir. Your private attorney is here present.
Your Honor, while
sorry?
Miss-
Dan McKenna on page 19.
and Your Honor, counsel and I spoke, and I believe we have an agreement if it's acceptable to the court.
Yes, we do, Your Honor.
All right, let me just read for the record. Mr. McKenna, good morning. You are before the court on one charge for aggravated assault with a deadly weapon without intent to kill, and what does the parties agree
Your Honor,
to?
I spoke with counsel, and he's provided me information about Mr. McKenna that I've taken into consideration. We've agreed to a $5,000 bond, no victim contact, no possession of any firearms, weapons, ammunition, until further order of the court.
Based on what I'm seeing, I find probable cause, and per the agreement of the parties, it'll be a $5,000 bond, an order of no victim contact. So, Mr. McKenna, that means no phone calls, no text messages, no third-party contact, no social media. And there will also be an order that you possess no weapons, firearms, or ammunition. If you are in possession of any of those items, you will have to surrender them to law enforcement. All right.
Understood, Your Honor.
Thank you, gentlemen.
Thank you, Your Honor.
Page 22, Steve Alarian. His private attorney, Mr. Schwartz, is present.
Good morning, Your Honor.
Good morning, Mr. Schwartz. How are you?
I'm good. How are you?
I'm good so far.
That's good.
Mr. Alarian is in.
Oh, he's Conte, I believe.
Conti?
Yeah, I thought he was.
Okay, there he is. All right, good morning, Mr. Alarian.
Good morning, good morning.
Mr. Alarian, you're before the court this morning on some ad charges. Charge 5 is for grand theft auto. Count 6 is possession of a fraudulent motor vehicle registration. Count 7, fleeing or eluding law enforcement at high speed. And count 8 is a felony probation violation with a no bond hold out of Dade County. I find probable cause, and I will hear from the parties.
Your Honor, considering the original charges that Mr. Alarian, he's already posted a $3,000 bond.
Okay.
Considering that he's on probation out of Dade County, I'd be requesting a $2,500 bond on count 7. The
Okay.
second-degree felony fleeing or eluding.
Thank you. All right, Mr. Schwartz.
Right, so in other words, the state is recommending $2,500 instead of the no bond on count 7?
No, count 7 right now needs a bond placed on it. It doesn't have a standard bond amount. So in other words, it would be counts 5 and 6 would each be 1,000.
Right.
Count 7 would be 2,500. The no bond I can't change because it's Dade County.
Right, I'm sorry. The fleeing eluding, though, is the 25.
Correct.
Got
That's
it.
correct.
Judge, I would ask for $1,000 on all 3. He posted bond the first time we were in court last Thursday. This is an additional charge, but if you look at the date, it goes back to August of 2018. This is not new. This has been, this information has been aware of law enforcement, been known to law enforcement since that time. He's been on probation. They've been in contact with my understanding is, that this was investigated by federal agent who was in contact with his probation officer back in 2018. Nothing happened for over a year now, and then I believe that the Miramar officer inherited it, and now this is new. So this fleeing and eluding is not what it appears to be, something that just happened recently, last week, arrested on a fleeing and eluding. This is something that's fairly stale. So I would say that, Judge, I would ask that the court consider the same bond for the count 7 as it is for 6, 5, and 6, given the circumstances and the timing. And like I said, they've known about this. In fact, they knew about it last week, just recently added on. These predate by a year and a half, last week's charges.
Honor, I consider it I consider it ironic, the argument for not setting the bond at $2,500 is because the date of when these events occurred. Well, he would have been in custody a lot sooner if he didn't flee from law enforcement at such an aggressive manner that they had to discontinue following him for public safety, and he fled into another county where they were unable to apprehend him. But for those actions, he would have been in custody a long time ago.
Let me just add the point that after that incident, they knew he was on probation. They found out where he was on probation. They had been in contact with his probation officer because they were investigating other matters. They made the decision back then not to charge him either here or to notify probation to have his probation officer violate him. So this was a decision made by law enforcement not to pursue charges over a year and a half ago, and then now recently they've decided to do it just this week. In fact, when we were in court, we thought that he was going to be picked up and taken to Miami-Dade, where he would deal with the probation violation. If you recall, didn't happen because they kept him here for this additional fleeing and eluding a year and a half later. So
Okay.
I think that's basically why we're here today.
All right, I don't need to hear any more argument from the parties. Based on all the allegations that Mr. O'Leary is dealing with right now, I don't think that the $1,500 difference is going to make or break either of your cases. I'm going to place a $1,500 bond on the fleeing and eluding charge. And then if he posts those bonds, then he can go deal with the no bond hold with Dade.
Which I understand if he posts it, they pick him up or they notify within 72 hours.
That's correct.
We heard, you explained it last time, but I
Yeah.
appreciate it.
All right, okay, thank you.
Thank you, Judge.
Okay. On page 17, Tavares Lee has family present and signed in. Ma'am, how are you? Do we know where Tavares Lee is? Where is he? Lee? Yeah, Tavares Lee. He's on page 17. Do we know which facility he's at?
Judge, who did you call me? I apologize.
This is Tavares Lee
Yeah,
on
right.
page 17.
Page 17, Judge.
I have that.
I haven't had an opportunity to speak to him. Can I speak to him one moment, please?
Okay, so that's fine. Do you want to just take a moment, or you want me to recall him?
Just a moment.
Okay, go ahead. Tavares Lee, page 17. Lee is the last name, L-E-E.
Judge, we're ready to proceed. Thank you, Judge.
Okay, thank you. All right, good morning, Mr. Lee. You're before the court on count 1, resisting an officer obstructing without violence. Count 2, driving while license suspended, third or subsequent offense. Count 3 is a misdemeanor violation of probation with a no bond hold on it. I do see that he has a hearing before his division judge tomorrow morning. I find probable cause for these charges, and let me first ask, ma'am, hello, what's your name? Crystal, are you related to Mr. Lee?
Yes, that's my boyfriend.
Okay. Are you here just to observe today, or is there something that you wanted to say?
Well, no, I just was observing to see if he had a bond.
Okay, all right, that's fine. Then let me hear from the attorneys if there's anything that they want to say.
I have nothing at this time.
Okay. Anything from the state? Okay, so in light of that, I'm going to leave the $750 bond in place on count 2. I can't change the no bond hold on count 3, so he will go before his division judge tomorrow morning to address that issue. Thank you. So, he has a hearing before his division judge tomorrow morning, 9 o'clock. Mr. Plant, did he leave me? Okay, he stepped out. I'll come back to him. All right, so until Mr. Plant returns to address the municipal ordinance matters, I'm gonna just start going down my stack here. First up is Chandalyn Sanders.
I believe Paul Ryan.
She is at the Paul Ryan facility.
Okay, thank you. Good morning, Ms. Sanders.
Good morning.
Ms. Standard, let me just confirm, since this is handwritten on here, this is a change of charge, is that correct?
Yes, Judge.
Okay, so Ms. Sanders, this is a change of charge to touch or strike battery domestic violence. And state, what was the original charge?
Your Honor, it's upfiled to felony battery due to a prior conviction.
Okay,
Judge McHugh originally set the bond at $1,000, no victim contact. I'm asking that bond and release conditions be kept in place. I'm confident Judge McHugh was made aware of her criminal history when setting the bond.
okay. Mr. Miller, anything you want to add on this one?
Yes, Judge. She's been in custody since December 8th and has been unable to bond on the $1,000 bond that she has. We're asking the court to reconsider placing her on pretrial release. She is a lifetime resident of South Florida, 2.5 years at her current address. She does have significant family connections here as well, and she does have a place to stay that's separate and apart from the alleged victim. She's advising that she's been on pretrial release beforehand and has done well.
Okay.
Your Honor, the defense already filed a motion to have the bond reduced last month before Judge McHugh. That was denied. At this point, if there's going to be any further modification, I think the alleged victim should have an opportunity to be advised to be present if he or she so wishes.
Based on the fact that it seems that the division judge has already denied this once, I'm not sure what other issues are going on in the case, so I'm gonna leave the $1,000 bond in place, as well as the no victim contact order. So Ms. Sanders, I know that you've been previously advised about this, but I'm just gonna repeat it because I have you here with me. The no victim contact order will remain, and that order means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, is there any way I can be released on pretrial release? I've been on it before and I had no problems in. I obeyed the rules.
I understand, ma'am. Your attorney told me that. I'm going to allow them to bring that issue before your division judge. So for today's purposes, I'm going to find probable cause and leave the bond in place as is.
I understand. I'll get another court date.
Yes, ma'am. That's correct.
Okay.
Thank you.
Okay, thank you.
So Montgomery? I'm not sure who's watching a training video, but I'm hearing it through my speakers.
She's here present, Judge?
Thank you.
Me.
Okay. All right. Good morning, Ms. Montgomery. Ms. Montgomery, you're before the court on one count of second-degree petty theft. I find probable cause, and I'll hear from the parties if they wish to be heard.
Judge, it's me, Ms. Montgomery. My understanding, I believe this incident took place at Walmart, and merchandise was recovered. Shouldn't be any restitution issues. So at this time, Ms. Montgomery has asked me to resolve this matter. So we wanted to see if the state had a plea offer for her.
State, do you have an offer for Ms. Montgomery?
I apologize, Your Honor.
It's all right.
Is the defense requesting an offer?
Correct.
Yeah. Offered be adjudication, time served, no return.
Patient, time served, no return.
Judge, she wishes to accept the state's offer.
All right. Thank you. Ms. Montgomery, will you raise your right hand, please? Do you swear or affirm to tell the truth?
Yes.
Okay. Ms. Montgomery, do you understand everything that we've discussed here today?
Yes, ma'am.
You can put your hand down. Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by accepting a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
And Ms. Montgomery, what plea do you wish to enter, guilty or no contest?
No contest.
Thank you. I accept your plea and find that it is freely and voluntarily given. Your sentence will be an adjudication, time served. There will also be a no return order, which means, Ms. Montgomery, you are not to return to the Walmart that we were discussing in this case. Do you understand that?
Yes, ma'am.
All right. Thank you very much. Good luck. 6 months. Shaquiana Mackey.
She's here.
Thank you. Good morning, Ms. Mackey.
Good morning.
Ms. Mackey, you're before the court on a traffic capias. This was a charge for operating without a valid license. I find probable cause, and I'll hear from the parties.
Judge, it's being Ms. Mackey. She wishes to resolve this matter. We want to see if the state had a plea offer for her.
Documented offers of withholding court costs.
Withholding court costs?
So a speeding ticket attached to this case.
Judge, she wishes to-
Consider dismissing in light of that.
Yeah. That's fine. The infraction would be dismissed. Okay, I'm sorry, Mr. Romero, did you say she wishes to accept?
Yes, Judge.
Okay, all right, Ms. Mackey, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Ms. Mackey, do you understand everything that we've discussed here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by accepting a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes.
And Ms. Mackey, what plea do you wish to enter, guilty or no contest?
No contest.
Thank you. I accept your plea and find that it is freely and voluntarily given. Your sentence will be a withhold of adjudication plus court costs. Good luck to you. Ray Ann Hewitt.
It's in,
Thank you.
Judge, I spoke to Ms. Hewitt this morning.
Yes.
She has private attorney Robert Maloff. I spoke to his assistant this morning.
Okay.
He's in Miami today. We left it at asking to reset, so if we can reset this to tomorrow.
Okay. So Ms. Hewitt, since your private attorney is not available today, they've requested that I reset this hearing to tomorrow. It's based on an ad charge. So based on that request from private counsel, I will go ahead and have it reset. So I'll see you tomorrow with your attorney.
Okay, thank you.
Thank you.
Your Honor?
Yes.
Could please court, at some point, if we could call a case out of turn, Damian St. John Miller on page 22, please.
Is he at Maine? That's fine. Go ahead. I'm looking for it anyway. So, Mr. Romero, Damian St. John Miller will be next. We're just looking for the paperwork right now.
Okay, Judge, I need some time to speak to him.
That's fine. Go ahead. Mr. Miller's reviewing the probable cause affidavit anyway. someone at one of the other facilities is watching a training video, will you just turn your mic off, please? Thank you.
Judge, whenever the court's ready, we're ready to proceed on Mr. Miller.
Mr. Miller, just let me know when you're done reviewing the paperwork and then we'll proceed.
Yes, Your Honor, I'm ready to proceed.
All right, good morning, Mr. Miller. You're before the court on 3 ad charges. Count 2 is a charge for rent for prostitution. Count 3, human trafficking, forced sexual activity of a child under 18 years of age. Count 4 is for living off earnings of a prostitute. I find probable cause for these charges, and I will hear from the parties.
Morning, Judge. Monique Pillinger for the state. With these charges, considering the victim is under the age of 18, there does not need to be any force or coercion to have probable cause for these crimes. The state is asking that Your Honor find proof evident presumption great on count 2. the human trafficking count, which is a life, count 3, which is a life felony, and appropriate bonds on the other 2 counts. The renting space count is a first-degree misdemeanor, and the deriving proceeds for prostitution is a second-degree felony.
Judge, in light of the count 1, the out-of-county hold.
Out of county hold on count 1, Mr. Miller, you said?
Your Honor, apparently there's a St. Lucie County hold, which is no bond.
Right, based on the allegations and the probable cause affidavit, for the purpose of first appearance, I do find probable cause as to all 3 of the ad charges. At this time, the court will exercise its discretion to make a finding of proof evident presumption great. As to count 3, that would be without prejudice for Mr. Miller to address that issue before his division judge. The standard bond will remain in place for count 2. Count 3 will remain at no bond. Count 4, bond will be placed at $50,000. Additionally, there's to be no contact with the minor in this case. No contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am.
Thank you.
Thank you, Judge.
You're welcome. Adriana Bowery.
Judge, you may recall Ms. Bowery was here yesterday,
Yes. Is she at North Broward?
and I spoke to her this morning and advised her that the immigration hold.
Okay. All right. Good morning, Miss Bowery.
Good morning.
I know this is an ad charge for an immigration hold. I know we discussed this issue briefly yesterday.
Correct.
I find probable cause, and Ms. Bowery, as we discussed yesterday, this has a no bond hold on it. I understand that you do have an attorney that you want to discuss that with, and that simply means that you'll be held no bond and will have to go before an immigration judge to address that matter, okay?
Okay, I'm speaking with my lawyer, the immigration lawyer, tomorrow afternoon.
Okay.
He come to see me.
Okay, all right,
Okay.
thank you very much.
Thank you. Bye-bye.
Ariel Sedella. Good morning, Ms. Sedella.
Morning.
Okay, Ms. Sedella, you're before the court this morning on count 1, first-degree petty theft. Counts 2 and 3 are each for felony capias. Those each have no bond holds and are not for magistrate. Count 4 is a traffic capias. I find probable cause for these charges, and I'll hear from the parties if they wish to be heard.
Judge, we have no objection to the convenience bond.
All right, the bonds will remain in place, and Ms. Sedella, you have a hearing before your division judge tomorrow morning. Thank you. Miriam Doomerville. Thank you. Ms. Doomerville. Ms. Doomerville, you are before the court on 1 count of grand theft auto. I find probable cause. I'll hear from the parties if they wish to be heard.
Judge, we're going to be asking for a phone order.
Okay. Phone? All right, I will sign that order, and I'll leave the standard bond in place at this time. All right. Mr. Plant, are you ready for me? All right, so I have Mr. Plant here for some of the municipal ordinance cases. On page 2, Kimberly Kelly.
Howard?
Thank you.
Downtown court.
She's in court?
Downtown court, yes.
Okay. Well, then we will have her reset. That was Kimberly Kelly on page 2. On page 11, Vernon Coleman.
Is that Maine, Your Honor?
Good morning, Mr. Coleman. Mr. Coleman, you're before the court this morning on 2 counts. Each are for a municipal ordinance violation. Count 1 is a trespassing, and count 2 is for possession of drug paraphernalia. I find probable cause, and Mr. Plant, what would Mr. Coleman like to do today?
His offer would be adjudicate time served.
Adjudication time served?
Yes, Your Honor. Both, I don't know if
All right, Mr. Coleman, if you want to resolve this case today, then the city's offer to you would be an adjudication time served.
Yes, ma'am.
Do you want to accept that offer?
Yes, ma'am.
Okay, will you raise your right hand, please? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. You can put your hand down. And Mr. Coleman, do you understand everything that we've discussed so far today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by accepting a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
And Mr. Coleman, what plea do you wish to enter? Guilty or no contest?
No contest.
Thank you. I accept your plea and find that it is freely and voluntarily given. Your sentence is going to be an adjudication time served. I'm also going to impose a no return order because I believe that there was a prior trespass warning on file for this location.
Ma'am, I couldn't hear your last part.
So, Mr. Coleman, what I said was that there's also going to be a no return order in place. That means that you're not to return to this location, all right?
Yes, ma'am.
Okay.
Yes, ma'am.
All right, thank you very much. Good luck.
Kill that mic, please.
Okay, Nicholas Mombrea, on page 13. Do we know where Mombrea is?
He may be medical. It says reset.
Are we resetting Mr. Mombrea?
I'm here, Your Honor.
Which facility?
North Broward?
Thank
North Broward.
you. Okay. All right, there's Mr. Mombrea. Good morning, Mr. Mombrea.
Good morning.
You're before the court this morning on a municipal ordinance violation for disorderly intoxication. I find probable cause. And Mr. Plant, what is the city's offer?
I'm told he wants to resolve his case.
Okay,
It would be
what's-
adjudicate time served.
All right, Mr. Mombrea, if you want to resolve the case today, the offer would be an adjudication time served.
Yes, Your Honor.
Do you wish to accept that offer?
Yes, Your Honor.
All right, will you raise your right hand, please? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. You can put your hand down. Mr. Mombrea, do you understand everything that we've discussed so far today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by accepting a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that illness today that impacts your ability to accept this plea?
Negative.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, guilty or no contest?
Guilty.
Okay, thank you. I accept your plea, and I find that it is freely and voluntarily given. And Mr. Mombrea, just one more time, your sentence will be an adjudication, time served. Good luck to you.
Thank you, Judge. Good luck, sir. Thank you, Your Honor.
Okay, was that all I had for you, Mr. Plant? Okay, thank you very much. All right, so I'm going back to the stack. Next up will be Amalia Pinaris.
North Broward?
Thank you. Good morning, Ms. Doomerville. Ms. Doomerville, you are before the,
This is Pinar.
oh, excuse me. You said Doomerville and it threw me off. Ms. Pinaris, good morning.
Good morning.
You're before the court this morning on counts 1, 2, and 3 are each a separate count for battery on an officer, firefighter, or EMT. Count 4 is disorderly conduct or breach of the peace. Counts 5, 6, 7, and 8 are each a separate count for resisting an officer or obstructing with violence. Count 9 is a charge for trespassing on property, not a structure or conveyance. Find probable cause, and I'll hear from the parties.
Judge, Mr. Linder and I discussed this case earlier,
Okay.
and if it pleases the court, we agreed to pretrial release with testing.
Pretrial release with random testing? All right. Okay, then I will accept that agreement. So Ms. Pinaris, you're going to be released or ROR'd on each of these counts to pretrial supervision. You will also be subjected to random testing. That means no alcohol, no intoxicants until further order of the court. Do you understand that?
Yes.
Before you are released, you will be getting some information about pretrial supervision. You must report to them within 24 hours. If you fail to do that, then a warrant will be issued for your arrest. Do you understand that?
Yes.
All right, thank you, ma'am. Roxanne Couch.
Thank you for pronouncing it right. North Broward.
Good morning, Ms. Couch.
Good morning.
All right, Ms. Couch, you are before the court this morning on count 1, possession of cocaine. Count 2 is disobeying a stop sign, which is not for magistrate. Count 3 is for having an expired tag. That is also not for magistrate. I find probable cause, and I will hear from the parties as to count 1.
Well, Judge, I spoke with Ms. Count earlier this morning. She's been residing in South Florida for more than 10 years. She's been at her current address for the past 2 years. All of her family lives here, so she does have strong family ties. So we're asking the court to consider pretrial release for her in lieu of this $1,000 bond.
Fine with that, Your Honor. I would ask for random testing.
Right, Ms. Count, I'm going to ROR you on count 1 and release you to pretrial services. You will be subjected to random testing. That means no alcohol, no intoxicants until further order of the court. Do you understand that?
Yes, ma'am.
All right, and before you are released, you have that information that the deputy just gave you about pretrial. You must report to them within 24 hours. If you fail to do that, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
Okay, all right, thank you very much.
Thank you.
Shari Bennett. Have J. Shari Bennett at Maine.
She's here, present judge.
Thank you. Good morning, Ms. Bennett. You're before the court on count 1, grand theft auto. Count 2, resisting an officer or obstructing without violence. Count 3 is for operating a vehicle without a valid driver's license. I find probable cause, and I'll hear from the parties.
Nothing to add from the defense, judge.
Anything from the state? All right, in light of that, I'll leave the standard bond in place on count 1. Thank you. Cassandra King.
Come on, Ms. King. She's approaching, judge.
Thank you. Good morning, Ms. King. Ms. King, you're before the court this morning on count 1, possession with intent to sell, manufacture, or deliver cocaine. Count 2 is for second degree petty theft, third or subsequent offense. Count 4, possession with intent to sell, manufacture, or deliver alprazolam, which is Xanax. Count 4, trafficking in fentanyl, 4 grams, less than 14 grams. I find probable cause for these charges, and I'll hear from the parties.
Judge, specifically as to count 4, $75,000 bond is something that Ms. King nor her mother is going to be afforded to post on her behalf. Now, from what she advised me, she's 34 years old, been here her whole entire life. She is working. She works at a local restaurant, I believe it's called Shake Shack. It's located here in Fort Lauderdale. She's a cook there. She's been employed with them for about a year and 2 months. Her take-home pay is about $389. Now, she lives in Pompano Beach with her mother. They rent. Their monthly rent's about $1,200. From what I'm being advised, Judge, her mom is elderly. She's on disability, and Ms. King helps her. Judge, they're not going to be able to afford to pay that $75,000. We're going to ask the court to consider a bond reduction from $75,000 to $10,000. Now, my understanding is Ms. King has prior contact with the criminal justice system, but I believe since April 2014, she's had a clean record, Judge.
I'm going to be requesting that the court keep the bond in place. Actually, Ms. King has already gotten a significant bond decrease unintentionally based on being mischarged. I would direct the court's attention. The listed weight of the fentanyl was 26.8 grams. She was charged with trafficking between 4 and 14 grams. The standard bond for trafficking fentanyl between 14 and 28 grams is $250,000. If convicted, carries a 15-year minimum mandatory prison sentence. Also considering, just Your Honor, just the public health issues that are going on right now, specifically with respect to fentanyl, that it takes granules, frankly, to cause an overdose, and that Ms. King was found in possession of almost 27 grams. I do believe the bond that is set at $75,000 is appropriate. Her criminal history: 2013 grand theft, a year and a day state prison; felony theft 2011, grand theft 2010, a year and a day state prison; theft 2010, uttering a forged instrument, and grand theft 2008. Delivery of cocaine, possession of cocaine with intent 2008. The other thing I would note, Your Honor, Mr. Romero is providing information that Ms. King advised him of her financial resources, but when she was arrested, she was in possession of $2,500 in U.S. currency in small denominations.
This time I'm going to leave the standard bonds in place in Ms. King's case. Thank you. Julianne Stabler.
North Bar.
Thank you. She at Paul Ryan? Julianne Stabler. I'm being told she might be at North Broward.
No, Your Honor, Stabler's at Port Ryan Facilities,
Okay.
Unit C3.
Thank you. All right, so Paul Ryan, do you have Julian Stabler?
No, Your Honor, but I can get her. Just need about 5 minutes.
Okay, just let me know when she's ready. I'll go ahead and then I'll come back to her.
No problem.
Thank you. Stacy Groover?
No problem, Your Honor.
Thank you.
Yes, Your Honor.
All right, good morning, Ms. Groover.
Good morning.
You are before the court this morning on count 1, possession of fentanyl, count 2, possession of heroin, count 3, possession or use of drug paraphernalia, count 4 is for introducing contraband into a detention facility. I find probable cause, and I'll hear from the parties.
Judge, we're asking for pretrial release for Ms. Gruber. She is a lifetime resident of South Florida. She's been living at her current address for about 8 months. She lives with her boyfriend, and she has a job working selling concert T-shirts.
Ms. Grover is a good candidate for pretrial. And this is just based on her past. I'm showing, well, first off, as far as her criminal history, 2018 possession of fentanyl. She violated probation April 17th of last year, was sentenced to 180 days in county jail. She was released June 15th of last year. 2018 possession of drug paraphernalia. 2018 failure to leave property. 2017 failure to leave property. Public aid fraud. 2015 possession of hydrocodone. 2013 oxycodone and cocaine. 2012 she violated probation in both of those cases. Multiple other drug priors where she violated probation. I would also note the last time she was put in pretrial in 2018, she had to be, her judge, Judge Duffy had to issue a warrant for revoking her pretrial for violating because she failed to report to pretrial and her whereabouts were unknown by pretrial.
This time, I'm going to leave the standard bonds in place on Ms. Gruber's case.
I can't hear, I'm sorry.
Ms. Gruber, I understand. I know it's a little loud sometimes. I'm going to leave the standard bonds in place on your case at this time. And so the next thing that will happen is you'll go before your division judge. Your attorneys will be in touch with you shortly to let you know what's going on with that.
Okay, do you know when I'll go to court?
I don't know that yet, Ms. Gruber, but hopefully it will be sometime soon.
Okay, thank you.
Thank you. Otis Nelsons Jr. I'm assuming he's at me.
Mr. Nelsons is approaching, Judge.
Thank you. Good morning, Mr. Nelsons.
Good morning.
You're before the court on count 1, aggravated battery with a deadly weapon, domestic violence. Count 2, causing a cruel death or pain and suffering to an animal. I find probable cause, and I'll hear from the parties.
Your Honor, I'm going to be requesting a $10,000 bond on each count, pretrial release with a GPS monitor, no victim contact. His history, 2017, DUI with an enhanced breath, unlawful use of false name ID 07, resisting without violence 04, sale delivery of cocaine within 1,000 feet of a school 97, VOP 30 months state prison. But frankly, what is of greater concern is the level of violence. That he's alleged to have cut the victim with a pocket knife and then strike her in the back of her head with either a glass bottle or a wine glass. But this, frankly, that level of violence is overshadowed by the allegations that he kicked the family dog, a puppy, in the head, causing multiple skull fractures and ultimately causing the dog to be euthanized.
Judge, in reference to the monetary bond on count 1, we were going to be asking for a $3,500 bond. My understanding he is working, Mr. Nelson is working. He works for a Total Landscaping company. He's been employed with them for about 5 years. He makes about $12 an hour. So financially, from his resources, there's no way he's going to be able to afford what the state is asking for. He has no problem abiding by the court order as far as no contact with the alleged victim. He does have family that resides in Broward County that he can stay with. My understanding, Judge, his father is a mechanic He's going to be relying on him to help post his bond, but he's not going to be able to come close to what the state is asking for. I'm going to be requesting a $3,500 bond on count 1, Judge, asking the court to keep the standard bond in place on count 2. And I'm going to be requesting a photo order so we can photograph the injuries that Mr. Nelson sustained as well, Judge.
We'll sign a photo order.
Oh, and Your Honor, and I apologize. I meant to also request as an additional release condition that Mr. Nelson's not possess or own any domesticated animals until further order of the court.
This time I'm going to place a $10,000 bond on count 1. I'm going to increase the bond on count 2 to $5,000. If Mr. Nelsons does post his bond, he will be placed on pretrial supervision with a level 2 GPS. Additionally, as a condition of release, he will be subjected to random testing, no alcohol, no intoxicants. Additionally, he is not to possess any domestic animals until further order of the court, and he is to have no victim contact. Mr. Nelson, no victim contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand these conditions?
Yes.
Thank you. Yes.
See if we could take Mr. Selvin Soto out of order. He's on page 14 of the court's docket.
Okay. Give me just one moment.
Your Honor, I also have Stabler here for one.
Okay, give me one moment. Is Soto at Paul Ryan? Let me just grab the paperwork. 1 second. All right, good morning, Mr. Soto.
Good morning.
Mr. Soto, you were before the court on an ad charge this morning. This is an additional charge for burglary of an unoccupied structure unarmed. I find probable cause, and I'll hear from the parties.
Your Honor, I'm requesting a $2,500 bond. Mr. Soto has a $25,000 bond and a GPS on an armed burglary and a no bond hold on a burg bat. I'm
Judge,
sorry,
in light of
on an
the-
aggravated battery. I guess there was a bond surrender and it was revoked.
It's an aggravated battery.
Judge, in light of the no bond hold in count 2, defense is going to stand muted this time.
Okay. All right, very well. In light of the other bonds, including the no bond hold that have been set, I'm going to impose a $2,500 bond on this charge. And that'll be it. Thank you, Mr. Soto.
Thank you.
Okay, and next you have Ms. Stabler there, Deputy?
Yes, I do, Your Honor.
Okay, so Julianne Stabler will be next. All right, good morning, Ms. Stabler.
Good morning.
Ms. Stabler, you're before the court this morning on count 1, petty theft, third or subsequent offense. Count 2, possession of cocaine. Counts 3, 4, 5, 6, 7, 8, and 9 are each felony probation violations with no bond holds. I do see that you have a hearing set before your division judge tomorrow morning. I find probable cause for these charges. Do the parties wish to be heard on counts 1 and 2? Stay.
Sorry?
Do you have anything you want to add on
Oh,
count
no,
1?
no, no.
Mr. Miller, anything? Julianne Stabler. I'm not sure what page she is.
Judge, in light of the no bond holds and the violations of probation, we're going to stand muted this time.
All right. Then I'm going to leave the standard bonds in place on counts 1 and 2. And Ms. Stabler, you'll be seeing your division judge tomorrow morning to address the probation violations.
I appreciate it.
Thank you.
She's a referral. Mental health wants them.
Connie Adkins. Thank you. Good morning, Mr. Adkins.
Good morning.
Mr. Atkins, you're before the court this morning on count 1, burglary of an occupied dwelling, unarmed. Count 2 is aggravated battery with a deadly weapon, domestic violence. I find probable cause.
Judge, I'd like to make an argument as to probable cause on count 1.
All right.
It appears from reading the probable cause affidavit that there's some relationship between Mr. Akins and the alleged victim in this case. They apparently have 2 children in common. According to the PC, he entered the house through a kitchen door, yelled at the alleged victim, and that's it. And so I'm arguing that because there was no intent to commit a crime or an allegation of an intent to commit a crime, there is no burglary. This is simply a trespass, and I'd ask the court to find probable cause on that count. And the fact that the alleged victim was in fear is irrelevant because he didn't do anything other than yell at her. He didn't raise his hand. There's no allegation that he brandished a weapon. Nothing to cause her to be in fear for her life. According to this, it sounds like she was in histrionics.
Well, Your Honor, I completely disagree. I think the history between these parties, any reasonable person would be in fear. I would note, Your Honor, and I would ask the court to take judicial notice of count 2, the aggravated battery that involves the same alleged victim that occurred months prior, where he's alleged to have attached or threw a brick at her. There is history of violence by Mr. Akins against this alleged victim, and any person in her situation, if he, without permission, entered her home and refused to leave, I think any reasonable person would be in fear.
And Judge, again, her being in fear without him doing something more is irrelevant to the charge. There has to be an allegation that he intended to commit a crime, and there is no allegation in this probable cause affidavit that he intended to commit a crime.
And Your Honor, stealthy entry, if there's stealthy entry, there's a presumption that there's intent to commit a crime therein. Clearly, he didn't knock on the door. He opens the kitchen door and slides his body inside. Obviously, she wasn't aware of it. It would not appear, because it says when she realized he was inside. So I think that would qualify as a stealthy entry into the home.
I appreciate the arguments that you both made. I understand that sometimes it can be a very thin line, but based on the totality of the circumstances, given the history between the parties and the information within the probable cause affidavit, for first appearance purposes, I'm going to make a finding of probable cause as to count 1. And I will hear argument as to bond.
As far as bond, Your Honor, on count 1, I'm asking for a $5,000 bond. On count 2, a $10,000 bond. No victim contact, pretrial release of the GPS monitor. As I mentioned earlier, there is a history of violence by Mr. Atkins against this same alleged victim. In 2018, he was arrested for aggravated stalking against the same victim. That was dropped. He did plead out to, in 2017, violation of a pretrial release condition. That release condition was a no contact order for a battery that he also pled out and criminal mischief against the same alleged victim as well. Your Honor, he has shown in the past, that, and I imagine there will be a no contact order issued in this case, he has shown in the past that he is not willing to comply with the judicial order of not having contact with this victim. As you see here, there's 2 separate incidents. One, a felony level of violence against this woman, and then at a later date, unlawfully entering the victim's home.
Judge, if I may, I haven't read the PC affidavit, but I'm sure there's more to it than meets the eye here. Having spoken to Mr. Atkins, I do realize on count 2, the alleged victim is the same person involved in 1. My understanding, that happened, the date of its offense, I believe it happened in summer of last year. Since then, they've reconciled. Mr. Atkins is actually living at the premises. they have kids in common. Now, unfortunately, there are sometimes marital problems with person, maybe infidelity, people coming home late, and then basically a person shows up, and then one day to the next, person doesn't want him living there. But my understanding is he does have belongings still at the residence. Judge, I understand the court has found probable cause, but for mitigation purposes, I think there's more to it on count one. I'm going to be asking the court to consider $3,500 on count one. Now, he did advise me he can follow the court's order as far as no contact, and he has a different family member that lives in our community, specifically in Miami, his aunt, that he could stay with during the pendency of this case, but unfortunately she is not working. Mr. Atkins is working. He works at a local labor pool. He's been doing that for about 8 months, and you get paid daily anywhere from about $60, $80 a day. So financially, he's not going to be able to afford the $15,000 which the state has asked for. My understanding is prior contact with the criminal justice system, but I don't think anything recent, as the state has advised us. So, Judge, I'm going to be asking for a $3,500 bond on count one, $3,500 bond on count two. I'm asking for a total of $7,000 bond on Mr. Atkins' behalf.
And I would just note, first, I don't think what Mr. Romero is sure of is really relevant to the proceedings, but he did advise he's not read the PC affidavit. I would note, according to the affidavit, post Miranda, Mr. Akins advised law enforcement that he went to the victim's house to speak to her. That definitely doesn't seem to be the statement of someone that resides in that home.
Was there, state you were discussing some of the prior history. Is there a permanent injunction between these parties?
No, the violation, Your Honor, it was, he was arrested for a battery. He was ordered to have no contact. There was an allegation that he violated the no contact order. I don't see anything about an injunction.
This time, I'm going to impose a $5,000 bond on both counts 1 and 2. If Mr. Adkins does post his bond, he needs to understand, number one, there will be a no victim contact order in this case. Whether there's an allegation they have reconciled or not, that is of no concern to the court. No victim contact means no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media until further order of the court. Do you understand that, Mr. Adkins?
Yes, ma'am.
All right. Additionally, if you post your bond, you will be placed on pretrial supervision with a level 2 GPS monitor. Eduardo Rodriguez will be next.
Come on up, sir. Please approach the judge.
Thank you. Good morning, Mr. Rodriguez. You're before the court this morning on one count of trespassing on property, not a structure or conveyance. I find probable cause, and I'll hear from the parties.
Judge, Mr. Rodriguez is interested in resolving this case. We want to know if the state had a plea offer for him.
State?
Yes, Judge. It'd be adjudication, time served, no return.
Adjudication, time served, no return.
Judge, he wishes to state's offer.
Thank you. Mr. Rodriguez, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Do you understand everything that we've discussed here so far this morning?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by accepting a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, guilty or no contest?
No contest.
Thank you. I accept your plea and find that it is freely and voluntarily given. Your sentence will be an adjudication, time served. There will also be a no return order. So, Mr. Rodriguez, you need to understand that no return means you are not to return to this location, which I believe is a motel. Do you understand that?
Yes, ma'am.
Thank you very much. Good luck to you. Dylan Holtman.
He's approaching, Judge.
Thank you. Good morning, Mr. Holtman. You're before the court on count 1, violation of probation. This is a misdemeanor matter. Count 2 is a misdemeanor capias. I find probable cause. I'll hear from the parties, if they wish to be heard.
Nothing from the state.
Judge, considering it's a VOP, at this time, nothing to have from the defense.
All right, thank you. The bonds will remain in place, and Mr. Holtman, you have a hearing before your division judge tomorrow morning. Roger Wilson.
Come on up, Mr. Wilson.
For the court on 1 count of first-degree petty theft, I find probable cause. We'll hear from the parties.
Judge, Mr. Wilson wishes to resolve this matter today.
Is there an offer from the state?
Your Honor, even though it is a very small dollar amount,
Yes.
it does appear there's potential restitution. Because it is such a low amount, though, I don't have an objection to an ROR.
Get that
All
from the
right.
state.
Then, Mr. Wilson, you're going to be released, ROR. I need you to understand that even though you are being released today, that doesn't mean that this is the end of the case necessarily. That means it will be your responsibility to remain in contact with your attorneys in the clerk's office to know any future court dates that you need to be present for. Do you understand that?
Yes, ma'am.
Okay, thank you. And Mr. Romero, it's not a pretrial, it's just an ROR.
It's instructions to contact the clerk's
Okay.
office to find out future court dates.
Okay, great, thank you.
Okay, good luck, sir. Read that and make sure you come back to court. Good luck.
Michael Brown.
Mr. He's approaching. Come on up,
Thank you.
Mr. Brown.
Good morning, Mr. Brown.
Morning, ma'am.
Mr. Brown, you're before the court this morning on a misdemeanor capias. This was a charge for loitering and prowling. I find probable cause, and I'll hear from the parties.
Judge, Mr. Brown wishes to resolve this matter today.
Is there an offer from the state?
Withhold court costs.
Withholding court costs.
Judge, he wishes to accept the state's offer.
Thank you. Mr. Brown, will you raise your right hand, please? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. You can put your hand down. And Mr. Brown, do you understand everything that we've discussed here so far today?
More or less, yeah. One moment. Yes,
Go
ma'am.
ahead.
Is there anything
I
you're
just wanna
unclear
make
about
sure.
that you need to ask me? Currently, no. I'll run across it. Okay. Yeah, I believe he understands if the court wishes to inquire again.
All right, Mr. Brown, do you understand everything that we've discussed here today?
Yes, ma'am.
Okay, now is the time. If you have any questions, your attorney's standing right there next to you. You can ask him.
I know, thank you.
Okay, is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, I understand.
Okay, and Mr. Brown, what plea do you wish to enter? Guilty or no contest?
No contest.
Thank you very much. I accept your plea and find that it is freely and voluntarily given. Your sentence will be a withhold of adjudication plus court costs. Good luck to you.
Good luck, sir.
Christopher Urso.
He's approaching, Judge.
Thank
May?
you. Good morning, Mr. Urso.
Yeah,
Mr. Urso, you're before the court this morning on count 1, second degree petty theft, first offense. Count 2, driving while license suspended, first offense. Count 3, attaching a registration or license plate not assigned to a vehicle. Count 4 is a traffic capias. And that is for failure to register a vehicle. I find probable cause, and I'll hear from the parties if they wish to be heard.
Judge, Mr. Urso wishes to resolve these matters today.
The offer on all counts, including the habeas case, would be a withholding court cost. From what I can tell, this would be a first DWLS.
Judge, he wishes to accept the state's offer.
Thank you. And Mr. Romero, did you explain to him the issue with regard to the DWLS, 3 or more?
I did, Judge. I did with the mandatory 10-day, I did, Judge.
All right, thank you. Mr. Urso, will you raise your right hand, please? Do you swear or affirm to tell the truth?
I do.
Thank you. You can put your hand down. Mr. Urso, do you understand everything that we've discussed here today?
Yes, Your Honor.
Is anyone forcing you to resolve your case?
No, Your Honor.
Are you under the influence of drugs or alcohol?
No, Your Honor.
Do you need any more time to speak with your attorney?
No, Your Honor.
Do you understand that you have the right to trial, but you are waiving that right by accepting a plea today?
Yes, Your Honor.
Have you ever been treated for mental or emotional illness?
No, Your Honor.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, Your Honor.
And what plea do you wish to enter, guilty or no contest?
No contest, Your Honor.
Thank you, Mr. Urso. I accept your plea and find that it is freely and voluntarily given. Your sentence on all counts will be a withhold of adjudication plus court costs. Good luck to you. Robert Lewis.
Conti.
Thank you. Good morning, Mr. Lewis. Mr. Lewis, you're before the court this morning on some ad charges. Counts 48, 49, and 50 are each for burglary of an unoccupied structure unarmed. Count 51 and 52 are each for grand theft auto. Count 53 is for first degree petty theft. Count 54 is for second degree petty theft. I'll hear from the parties.
Your Honor, Mr. Linder and I discussed
Yeah, I just want to put on the record first, Your Honor, this is an executive assignment case. I spoke with the Assistant State Attorney, Greg Credos of the Palm Beach County State Attorney's Office. He's handling the case. He advised me to relay to Mr. Miller in the court. He would be requesting a $1,000 bond on each of the burglaries. Mr. Lewis has a couple of no bond holds in Broward, and multiple bonds out of Palm Beach County.
Discuss this with Mr. Lewis. He understands what's happening, and we have no objection if the court, if it pleases the court.
Okay. All right, I find probable cause as to all the ad charges, on counts 48, 49, and 50. Bond will be set at $1,000 for each of those, and the standard bonds will remain in place for the additional charges. All right, thank you, Mr. Lewis. Sydney Cotledge. Mr. Cotledge at Maine. All right, Mr. Cotledge, you're back again. All right.
Yes, good to see you.
Well, it's good to see you, Mr. Cotledge, if only it wasn't under these circumstances.
The circumstances are okay.
It's all right. It's all right. We don't need to talk about it anymore. Okay, this is for, you're before me this morning for an ad charge. This is for second degree petty theft. I find probable cause, and I will hear from the parties.
Your Honor, I think they cut off, when they do the findings, they cut off the rest. It's third or subsequent offense.
I'm sorry. Oh, third or subsequent offense.
It's okay.
Yes.
I think it just gets cut off on the findings.
That's all right.
Your Honor, you granted pretrial release on the top count pending verification.
Yes.
I'm okay with the same.
And that's what I was gonna be asking about.
Okay. All right, that's fine. Then on this count, it'll be the same as the one that we discussed yesterday. Mr. College will be released to pretrial pending verification of the address that he provided.
Just ask for an order of no return to this establishment 5 below.
Yes. Yeah, okay. So, Mr. Cotledge, one of your release conditions is going to be a no return order. The location that's at issue in this case is the 5 below at 5767 North University Drive. That means that you are not to return to that location until further order of the court. Do you understand that?
Yes, ma'am.
All right, thank you very much.
Under this next case, Gilliard, there are 2 counts and apparently 2 offense reports. I only received the one relating to the dealing with stolen property. May I have a moment, Judge?
Absolutely.
Thanks. To count 2, Your Honor.
All right, let me just first say, Mr. Gilliard, good morning. For the record, you are before the court this morning on count 1, dealing in stolen property. Count 2 is for loitering or prowling. Mr. Miller, you said you have an argument as to PC on count 2?
Yes, Judge.
Okay, go ahead.
I think if I read the probable cause affidavit correctly, he was observed by law enforcement hopping a fence into a shopping plaza at about 8 o'clock in the morning. It doesn't seem to me that that would be alarming in any way. Hopping fences is not necessarily a criminal activity. There was a car alarm that went off. However, there's no allegation that he caused it or that he tried to enter a car or maybe rubbed up against it and caused it to go off. I mean, there's just nobody saw anything, and so they're making assumptions based solely on an alarm, and it just doesn't seem to rise to the level of loitering and prowling.
Question was there a reasonable concern for people or property? Certainly an officer hears a car alarm going off. There is only one individual in the entire area who is seen jumping a fence immediately after the car alarm going off. I think it is reasonable for that officer to have concerns for property in that area.
But also, like to note, upon my reading of the probable cause affidavit, and Mr. Miller, I totally understand what you're saying, but the issue in this case is, it appears this was a fenced-in employee parking lot next to a fire station. And based on the probable cause affidavit, it seems that the officer observed Mr. Joseph jumping the fence out of that parking lot right after a car alarm had gone out. So for first appearance purposes, I am going to make a probable cause finding on counts 2 and 1. And I'll hear from the parties as to bond.
Judge, Mr. Gilliard is not going to be able to post a monetary bond associated with either count, the $3,500 or the $25 bond. Right now, he advised me he's currently looking for employment. Right now, he's in between residences, so he's basically homeless. Now, he has a grandmother that lives in Miami-Dade County that he can receive future court notices to make sure he comes back to court. But there's no one that's going to be able to afford to post a monetary bond. So, Judge, at this time, I'm asking for the court to consider releasing Mr. Gilliard on pretrial release.
Your Honor, the state would object to pretrial. I'm actually going to be, based on the circumstances of count 2, I'm going to be asking for a $500 bond, an increase to $500 based on his history. Mr. Gilliard, he had a trespass and a conveyance, Palm Beach last year. Actually, was in December of last, from what I can see, December of last year was resolved. Burglary of a conveyance last year. Trespass, 2018. Burglary of a conveyance and attempted burglary of a conveyance, 2017. Burglary of a conveyance, dealing in stolen property, false verification of ownership to a pawnbroker, and theft, 2017. Burglary of a conveyance and theft, 2017. The issue, Your Honor, all of his priors are out of Palm Beach and Dade County. I don't have it, I can check, but I don't know that I have anything in my system to indicate if there's been failures to appear out of those counties. Because they're out of county, Your Honor, I really don't know.
Standard bonds in place on Mr. Gilliard's case at this time. Larry Perkins,
He's approaching, Judge.
thank you. Good morning, Mr. Perkins.
Good morning.
You were before the court this morning on a charge for violation of parole. I find probable cause as to this charge. And Mr. Perkins, so that you understand, this charge has a no bond hold, which means that you'll have to go before the parole board to further address this matter. Thank you. Pedro Gomez.
Judge, Mr. Gomez is here present.
Thank you. Good morning, Mr. Gomez.
Morning.
You're before the court this morning on count 1, petty theft, second degree, first offense. Count 2 is for possession of cocaine. I find probable cause, and I'll hear from the parties.
Judge, unfortunately, Mr. Gomez, at this time is not in position to post his monetary bond. Considering this is non-violent, we're going to ask the court for releasing Mr. Gomez on ROR. He did advise me as a place to stay. He'll be residing in Dade County. He'll be sure to come to future court appearances, but he's requesting an ROR.
Your Honor, I would be opposed to an ROR. I'm showing a total of 43 prior cases in the clerk system for the state. This Florida summary is showing there's a total of 27 cases without reported dispositions. This isn't necessarily in chronological order. 2011 out of Dade, resisting without violence. Resisting without violence, 2013 in Dade. Shift, resisting with violence, and that's Dade. It was 04 in Dade. Your Honor, based on the sum and substance, I'm not going to be. I understand if the court's inclined to release him on non-monetary release, but I would ask that he be supervised by pretrial with random testing.
All right. I will ROR Mr. Gomez to standard pretrial. He will be subjected to random testing. Mr. Gomez, that means no alcohol, no intoxicants. Do you understand that?
Yes.
Additionally, I want to advise you that you're going to be getting some paperwork from your attorney regarding pretrial supervision. You will have to report to pretrial within 24 hours. If you fail to do that, then a warrant will be issued for your arrest. Do you understand that?
Yes.
All right, thank you. So, March.
Who's here present, Judge May?
Thank you. Good morning, Mr. March. You're before the court this morning on count 1, possession of oxycodone. Count 2, trespassing an unoccupied structure or conveyance. I find probable cause, and I hear from the parties.
Judge, we're going to be asking if Mr. Marsh could be considered released on pretrial release. He's been here his whole life. He's looking for work. My understanding, Judge, I believe at the location he was trespassed, that's where he was staying with. Obviously, one of the release conditions I advised Mr. Marsh is there's going to be probably a no return. So he'll go and live with another friend who resides, I believe, in Lauderhill, and stay with him during the pendency of this case. But from what he advised me, he's not in a position to post a monetary bond, nor anyone else will be able to post one on his behalf. So that's why he's asking to be released on supervision.
Showing out of Palm Beach County in 2016, 2 separate sale delivery of cocaine, sale of controlled substance, sale delivery of marijuana, a 1 year and 3 months state prison, release from state prison 2017. I am showing 2 trespasses in Broward last year. I'm showing in his EOC info. 7 prior failures to appear.
Based on his history with the failures to appear, I'm not going to place him on pretrial services, or pretrial supervision, excuse me. I'm going to leave the standard bond in place on count 1. Additionally, I'm going to impose a no return order. Mr. March, no return means that you are not to return to the apartment that's at issue in this case. Do you understand that?
Yes, ma'am.
Thank you. Edison Brooks.
Judge, I've been advised he bonded.
All right, thank you. I find probable cause. Joseph Lata.
He's approaching, Judge.
Thank you. All right, good morning, Mr. Lata.
Good morning.
Mr. Lata, you're before the court this morning on count 1, possession of cannabis over 20 grams. Count 2, resisting an officer, obstructing without violence. I find probable cause, and I'll hear from the parties.
Judge, nothing to request from the defense. I believe his parents are in the process of posting his monetary bond.
Okay, anything from the state? All right, in light of that, I'll leave the standard bond in place on count 1. Thank you. Corey Smith.
He's approaching, Judge.
Thank you. Good morning, Mr. Smith.
Good morning.
Mr. Smith, you're before the court this morning on count 1, possession with intent to sell, manufacture, deliver cocaine within 1,000 feet of a convenience business. Count 2, possession with intent to sell, manufacture, deliver cocaine. Count 3, trespassing on an unoccupied structure or conveyance. I find probable cause. I'll hear from the parties.
Judge, specifically on count 1, Mr. Smith advised me he's not in a position to post the $7,500. I do realize the seriousness of the allegations, but we're going to be asking for the court to consider a reduction in bond to $2,500. He's 33 years old, been here his whole life. He works off and on for a landscaping company, so he's looking for stable employment. But whenever he gets a call that there's work, he shows up and he works there. Now he lives in Pompano Beach with his fiance and his 3 children. Now his fiance is incurring the majority of the financial burden of the household. She's a medical assistant, works for local urgent care. They have 3 children. So Mr. Smith, when there's no work, he stays at home taking care of his son, who has health issues, Judge. But I'm asking for a bond reduction on count 1 to $2,500.
I think at a minimum, $10,000 is appropriate, considering count 1 is a first-degree felony. As Mr. Smith is aware, he's already out right now on a possession of cocaine, and he's got 2 open felonies in Palm Beach County, each for sale of cocaine. And he faces a potential no-bond hold on all 3 cases, because now apparently he is violating his release conditions in the same nature of the charges he's being held, that he has pending.
All right, I'm going to leave the standard bonds in place on Mr. Smith at this time, given the history and the other pending cases that have been discussed today. Michael Downey.
He's approaching.
Thank you.
Come on up, sir.
Good morning, Mr. Downey.
Good morning.
You're before the court this morning on count 1, resisting an officer obstructing without violence. Count 2 is petty theft, second degree, third or subsequent offense. I find probable cause.
Mr. Doney was placed on pretrial supervision on the 1st of January and instructed to report, and as of today, did not report. He has subsequently picked up this new charge, and he's on supervision for 2034 CF10A. Based on the course finding of probable cause today, we're going to access pretrial status revoked at this time.
All right, I'm going to grant the request submitted by pretrial supervision in case number 2034 CF10A. His pretrial status is revoked. I'll hear from the parties as to bond. So now we have both of these cases to address. The case that was on pretrial carries 3 charges, which are all for petty theft as well.
Your Honor, I'll start with the cases on pretrial.
Okay.
I'd ask that the court, at this point in time, make those no bond and let his assigned judge decide how best to proceed. In addition, the court should be aware, on the case he's on pretrial for, he was arrested December 31st. 3 days prior to that, he was arrested December 27th on a new theft and 2 capias for another theft. He pled those out and was released December 28th. Before that, he was arrested November 18th on another theft, pled that out, was released November 20th. Before that, he was arrested October 24th on a municipal ordinance. He was ROR'd, and then he had an April arrest on, that's not loading, but from October 24th till now, Mr. Downey is showing that he cannot be trusted not to commit new law offenses if released from custody at this point, and certainly can't be trusted, frankly, to appear in court when he's not appearing to, was there an issue with him appearing? I never showed up, so we can't have much confidence he'll show up in court.
That's what I want. I didn't hear everything, so I'm assuming the basis of pretrial asking for his pretrial to be revoked is for him not abiding by pretrial release conditions. Judge, the only thing I can tell the court is, in speaking Mr. Downey, he's homeless. My understanding is this petty theft, I believe, if I'm correct, it happened sometime in December. Walgreens involved deodorant. He can't afford anything, Judge.
All right. I appreciate the argument, Mr. Romero, but based on Mr. Downey's history, I'm very concerned as to whether he'll appear for any court appearances and whether he'll commit any further alleged thefts at this point. So I'm going to grant the request to hold him no bond on the pretrial, the case that was on pretrial, and I'm going to leave the standard bonds in place on the new case. His division judge can address it further. Thank you. Michael Cooper.
Judge, medical loan?
Okay, thank you. Terrence Neal.
Please approach and Judge hear me.
Thank you. Good morning, Mr. Neal.
Oh, we're gonna ask.
Mr. Neal, you're before the court this morning on count 1, introducing contraband into a detention facility. Counts 2 and 3 are each for misdemeanor capiases. Those are related to charges for failing to register a vehicle and driving with a suspended license. I find probable cause. I'll hear from the parties.
Judge, I was gonna ask to see if his bond's been posted.
Let me just inquire with confinement. It's not showing in the system yet.
No problem. I will be contacting his girlfriend as far as the bond. However, in speaking, Mr. Neal, in reference to counts 2 and 3, I believe it's unrelated from count 1, Judge. He's asking if the state has a plea offer in order to resolve counts 2 and 3 today.
One moment. Yeah, the problem is, Your Honor, this incident occurred November 7th. It would be it'd be more than a third. He'd be facing a 10-day mandatory jail sentence to resolving this matter.
Mr. Romero, there's not going to be an offer at this time.
I understand. I'm going to be contacting his family.
Okay, all right, I'm going to leave the bonds in place. I do see that he has a hearing set currently before his division judge tomorrow morning. Thank you. Jeffrey Clark. Jeffrey Clark.
Sorry, who did you call?
Jeffrey Clark.
He's in courtroom 4750. Sorry, Judge.
Okay, that's all right. Is it
If I
is
could
it on
check.
these cases? I just wanna-
That's what I'm going to check right now, Judge.
all right.
Thank you. Sorry. I think he's in court on his VOP. He's got a VOP hold. You want to have him brought back, or these are not in custody. It's up to you, whatever you want. Check the VOP to see if you guys are. There's nothing in Odyssey on this one. Well, at least it's not in the public access. I'd have no objection, you guys, if you wanted to request that to be appointed on this case. Considering you are representing. No, well, it's because it's not in custody, so that if you want it, if the issue was being, okay, all right, that's fine.
That's okay. We all have to be here anyway. I'm sorry? Yes, thank you. Okay, next up is Carlton Blake.
Paul Ryan, I believe.
Thank you.
Judge Barry Williams is Mr. Blake's attorney. I spoke to him this morning, and he is asking the court to waive his presence for purposes of this hearing. No, Mr. Williams' appearance.
Your Honor, what I was going to be requesting, well, I guess we should see Mr. Blake, is, I think that might be him right there and Paul Ryan.
We have Mr. Blake at Paul Ryan.
give me the honor?
Do you have Mr. Carlton Blake there?
Yes, I do.
Thank you. All right, good morning, Mr. Blake.
Good morning, Your Honor.
Mr. Blake, you were before the court this morning on some change of charges. Counts 1 and 2 are for sexual battery on a victim 12 years old or less than 18 years old. Counts 2 and 3 are both for directing or promoting sexual performance by a child. I don't have a probable cause affidavit
Oh,
on this.
I mentioned to Shelley that this is one of the ones Your Honor, what I was going to be requesting, and I'll print it out for you if you'd like. We no-infoed several of the charges, but on counts 1 and 2, we actually upfiled those to first-degree felonies. What I was going to be requesting the court to do is to set the total bonds on these 4 counts where they will match the bonds that Judge Murphy said at his original first appearance. He'd be in the same footing that he was this whole time, and Mr. Blake is being arraigned tomorrow morning before Judge Coleman.
The total bond that's set.
The total bonds were at $70,000. So what I was going to be requesting is 30 each on 1 and 2, and 5 each on 3 and 4.
30 each on 1 and 2, and 5 each on 3 and 4.
Yes, ma'am.
He has arraignment hearing set for tomorrow.
Yes.
I'm sorry?
Yes.
Okay.
Yes. And just so the court's aware, if I, one moment. Mr. Blake also has a violation of probation hold, so there's no prejudice, yes, from the court's in these bonds.
All right, that's fine. Then I find probable cause, and on these, the change of charges, I'm going to grant the state's request. Counts 1 and 2 will each be set at $30,000. Counts 3 and 4 will each be set at $5,000. And Mr. Blake, you'll be seeing your division judge tomorrow morning for an arraignment hearing.
Your Honor, the only other request I would make, because I reviewed the original findings,
Yes.
and there's nothing written about no victim contact.
There's not?
There's not. It could have been ordered. It just might not have been written down on the findings.
Okay.
So I'd ask if the court be inclined to order no contact with victims with the initials KH, QS, and that is it.
All right, I have no issue with that. So, Mr. Blake, there's also going to be a court order in effect ordering no victim contact with the 2 alleged victims with the initials KH and QS. No victim contact means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, Your Honor.
All right, thank you very much. You'll be seeing your division judge tomorrow morning. Last case is going to be Jerry Decius.
Deputy. All right.
Spoke to Mr. Weinstein, who is Mr. Decius's attorney.
Okay.
And he asked if the court could reset this for tomorrow.
Okay. All right. So, Mr. Decius, these are for change of charges. Your private attorney was unable to be here this morning and has requested that this hearing be reset to tomorrow morning. So I'll see you back here tomorrow morning with your private attorney so that we can address these, okay? Thank you. All right. That concludes our morning session of first appearances. I'll see everyone back here this afternoon. Thank you.